today's world of high-speed connection, text messaging, and social networking, we often find ourselves searching for information. There are millions of blogs on the internet. News, sports, politics, and tech. But I bring it all together for you and present it in a relentlessly unconventional fashion. My name is Zenny Abraham, and this is the Blog Report. It's time now for politics. Hey everyone, well, Thursday was a big day, and I'm finally getting around to talking about what the Supreme Court did in upholding the Affordable Care Act, or more technically, the case of National Federation of Independent Business versus Sebelius. And you might wonder who Sebelius is. That's Catherine Sebelius, who is the head of the Department of Health and Human Services, the department that is charged with administering the Affordable Care Act, or what some people call Obamacare. Now, this video is not a conservative versus liberal argue fest. This video is dedicated to a more thoughtful discussion of how the Supreme Court came to the 5-4 decision it made on Thursday and what its implications are for proponents of limited government and for those persons like myself who believe in the appropriate role of government regardless of size. So let's get started. First of all, the decision went like this. The affirming side, the 5 side, consisted of John Roberts, Chief Justice, Sotomayor, Ginsburg, Breyer, and Kagan. Now, the dissent side consisted of Scalia, Alito, Thomas, and Kennedy, 5-4. The reason for John Roberts' decision in favor of upholding the Affordable Care Act as constitutional centered around the institutional mandate. You see, the healthcare law is essentially simple. It says that everyone must purchase some form of healthcare, but if you choose not to do so, keep that in mind, you have to pay a price, and that price varies. Now, the organization that's charged with telling you how much you have to pay and basically sending you the bill is the Internal Revenue Service, the IRS. But if you're poor, you don't have to pay. Keep that in mind. There's also no jail time attached if you don't pay. You don't pay, it goes into the same type of non-payment that any tax, oh, there's that word, goes into. Now that's key. Why? Because, first of all, John Roberts said that the idea that the Affordable Care Act was a child of the Commerce Clause was inaccurate because it did not regulate commerce. It actually caused commerce to occur. In other words, I say you have to buy healthcare, therefore I am having you pay into the industry that exists. I'm not regulating the operation of the industry. You understand? It's a big difference. He says, however, that it is essentially a tax and not a penalty. That's a big deal because in many of the lower court battles, when the healthcare law lost, and when Obamacare lost, it hinged on the idea that, hey, this is not a tax at all, it's a penalty, and you shouldn't penalize people because some courts figured the penalty was unconstitutional. No. John Roberts is saying this is not a penalty, it really is a tax. And if you think about it, technically he's correct from an entirely other perspective I hold. And I've held this perspective since day one of the Affordable Care Act. Here's what I mean. The Affordable Care Act is designed to prevent the age-old problem of the free rider. What do I mean? That person that's out there right now that is in an ambulance paid for by the taxes that are put in by the county, and so they go into an emergency room, and basically the public, the state, cares for that person, all right? So in this new environment, that person has to get health care. They have to. Or they have to pay a penalty, unless, of course, they're too poor to afford that amount. But that amount they're paying really is such that if they can't pay it, there's no jail time. So it's not in the truest sense of the meaning of the term penalty, a penalty. It really is just a tax. President Obama said there is no tax increase with this. And he's right. There is no tax increase. But there is a new tax. And that's what this is. It says, this is what you must pay. And it's right. Why? Because, again, let's say you've got 5 people in your room. And of the 5, 3 decide to buy health care insurance and 2 don't. So let's say of the 2 that don't, both of them get into accidents, and the pool of money that you have paid in, guess what? They have to use. Now, their payments theoretically should offset that to some degree, right? What if they don't pay? Now, what if you have health insurance and the 3 of you have it, and the 2 that don't have it consistently get into health trouble, and they're using the system and they're draining costs at a great rate, but they're not paying into it. They're the free riders. That technically is what we have today. The Affordable Care Act was designed to really eliminate that problem, or at least come to some degree of measure of providing an entirely different system that makes that problem less likely to occur. So it is a tax. That's what it turned on. Now, there have been a number of interesting legal arguments. In fact, I recommend you go to SCOTUS blog to check out some great arguments. Regardless of what side you are, it's just a great place to get an excellent round of intelligent conversations in text about the Supreme Court's decision on this case. One aspect of the case that really interests me is the idea that Congress can't regulate commerce. They can't tell you what to buy. But in 1792, with both sides of Congress present and George Washington there, that's exactly what our government did. It said that every able-bodied man had to purchase a firearm. What is that but enacting people to buy into and therefore create commerce, right? That's exactly what was done. And in a sense, I argue that we do that when we say, for example, that you have to have seatbelts in a car, and therefore the automobile manufacturer has the right to charge you extra for that seatbelt, even though the federal government says the seatbelts must be in the car. So that's another way of not just regulating commerce, not regulating commerce, but igniting the existence of a commercial act. All right. So the bottom line is that that's what the law turned on, but the dissenting opinion and Judge Roberts' arguments really do lay a foundation for a fascinating legal future. Do other groups have the right to come to Congress and essentially call for laws that force us to purchase certain things? That could happen. Furthermore, what is the role of the Commerce Clause? And how do we reconcile the idea that the Affordable Care Act, according to Justice Roberts, isn't really protected by the Commerce Clause, and Congress can't, in his mind, force a commercial act? But in the past, and I used the law where we had to actually, every able-bodied man had to buy a gun, actually caused that. That's still up in the air for me, and I'm not the only person that thinks this. So that is the end of my encapsulated conversation about this. I'd like to know what you think. And please, your thoughtful ideas and observations.